Now, should we move on and examine the substance of the Australian Constitution?
Let's start with the race provisions.
With Section 21 of the Constitution allowing the state government to extinguish people's right to vote based on their race, and Section 51(26) allowing the Commonwealth Parliament to make laws on people either for benefit or detriment purely because of their race, they undisputably foster racial discrimination.
And history shows the idea of race as a social invention to justify exploitation, enslavement, and other social injustices.
They have to go.
Well, it's possible. An overwhelming majority of participants supported removal of Section 25 and Section 51(26). With a society that no longer finds racial discrimination acceptable, Section 51(26) should no longer apply.
The panel did contemplate all the suggestions and decided that Section 25 should be repealed rather than replaced or amended to unify the entire Australian nation. This is legally possible, as researchers found that there would be no legal, structural, or interpretive risk in doing this.
But that wasn't the only way to recognise Aboriginal and Torres Strait Islanders people in the Constitution.
Well, no. Others have also supported the panel's recommendation of replacing Section 51(26) with a new head of power to make laws with respect to Aboriginal and Torres Strait Islander peoples, called Section 51A.
Professor George Williams stated it is important that the racist power does not simply be repealed. An important achievement of the 1967 referendum was to ensure that the federal parliament can pass laws for the Indigenous peoples in areas like land rights, health, and protection of sacred sites. The most appropriate way of fixing the racist power is to grant power to the federal parliament to pass laws for Aboriginal and Torres Strait Islanders.
The proposed benefit law will not be based on race, but on Aboriginal and Torres Strait Islanders people's unique place in the history of the country and their prior and continuing existence. Tony Abbott and Kevin Rudd have both acknowledged the unique nature of Aboriginal and Torres Strait Islander peoples and culture.
The expert panel considers that statement of recognition embedded in Section 51A would be the best option in order to retain a Commonwealth power to legislate pertaining to ATSI peoples whilst getting rid of the race power, and would also avoid unintended consequences. He would also avoid debate about a no legal effect clause. However, it is up to the government whether or not they decide that current laws supported by the current power may continue to be supported by the new power without reenactment, and up to the courts to determine whether Section 122 is to be constrained by Section 51A as well as Section 51(31). Although the risk of removal may affect crucial existing laws, and future laws needed by the people may not be constitutionally valid, the panel thinks that other heads of powers may empower these important legislations. The new head of power would come with its own preamble. This preamble would make clear that laws empowered under this head of power would operate to benefit ATSI as a whole rather than a law concerning mere individuals.
More should be done. There were submissions for ATSI history to be taught in schools, but what about submissions proposing Parliament have the ability to make laws preserving language and identity?
Well, the panel also suggested creating Section 127A, a language provision declaring ATSI languages not as national languages but as original Australian languages. Numerous suggestions suggested that recognition of culture and languages would be a unifying experience for Australia. Additionally, the National Indigenous Language Survey recognized that language, land, and culture are as one. Languages are storehouses of cultural knowledge and tradition.
Although the panel found there may possibly be unpredictable legal consequences, in its totality the panel do recommend this, and the participants generally supported this idea.
Giving more recognition to the ATSI is important, but how do we ensure that Australian society doesn't relapse back to its historic ways of racial discrimination?
Well, international disapproval of racial discrimination is demonstrated by signatories worldwide supporting the United Nations' endeavour to prohibit racial discrimination. In signing the United Nations Declaration on Rights of Indigenous People and ratifying the International Convention on the Elimination of All Forms of Racial Discrimination, Australia has made it their international obligation to eliminate racial discrimination, especially towards the Indigenous Australians. In times of drastic inequality, the Convention gives Australia power to implement special measures advancing a particular race. Deemed as non-discrimination and relative equality, it protects racial groups who are historically made vulnerable by discrimination to foster and secure equality. I'm sure this has had a huge influence over Australia domestically.
Definitely. The High Court in Mabo called international law a legitimate and important influence. The Native Title Act actually intended to rectify the consequences of past injustices by the special measures contained in this Act.
However, although some sort of Bill of Rights seems unrealistic, the panel recommended and received outstanding support for constitutional provision protecting Aboriginal and Torres Strait Islander peoples, as well as every other ethnic group in Australian society, from discrimination.
The panel has been cautious because of the special position of ATSI in Australian history. Subsection 2 importantly authorises Parliament to take special measures for advantageous treatment, and this cannot be invalidated for infringing a general guarantee of racial equality.
This is a really important step for Australian law. The panel has noticed social change away from the mindset of society in the 1900s and constitutional non-recognition of Aboriginal and Torres Strait Islander peoples. Even in that era, there had been groups like the Constitutional Commission and individuals like the Attorney General Andrew Inglis Clark in the 1800s that had supported and recommended a change in this direction.
Social change is evident in current state and Commonwealth legislation that prohibit discrimination due to race, colour, descent, nationality, or ethnic origin. As a submission stated, as long as the allowance for racial discrimination remains in our Constitution, it continues in subtle and unsubtle ways to affect our relationships with each other. We should be rewarded on our merits and assisted in our needs. Race should not matter.
If any viewers would like to know more about the suggestions to change the Australian Constitution that did not make the cut for the expert panel's recommendations, please click the link below to find the original document for the expert panel recommendation. Bye!